Imagine this. Your shipment lands at the customs airport and you are excited to deliver the goods and make some profit out of it. And then bomb. Customs has stopped your shipment. And later you are told that it is because of IP infringement. But nobody told you what is this IP and whose IP it is. Later you found that it is because of a patent belonging to a competitor, and that too which expired 2 years ago. This is not a fictional story. It has exactly happened to one of our clients. And what we did next has changed everything for our client. Was till the end, I will declutter how to instantly recognize when your shipment is illegally detained for IP infringement and how to use IPR rules to turn the tables legally and powerfully. If you are an importer and this happens to you, do you even know where to start? Let me explain what we did for our client to come out of this situation so that you can apply the same when you face it. Our client imported agriculture equipment, they paid customs duty and they even got the out of charge order. But suddenly the customs flags it and stops the clearance of shipment. When we asked for the reasons, they said this is an IP infringement case and there is a court order. When we asked for additional details, they don't have anything else apart from these two words. Interestingly, the court order neither made the customs as a party to the case nor banned the import of such goods. The customs authorities can't just act on vibes. In an IP infringement matter, the customs authorities shall follow the customs IPR enforcement rules 2007. As per rule 3 and 4 of these rules, the owner of IP must file an application with the customs authorities to register the IP. Thereafter, the customs authorities will look at the application. If they feel it is valid, they will register the IP. As per rule 5, if the customs authorities register the IP, then the IP owner is supposed to execute a bond to protect the importer in case the IP turns out to be invalid later. As per rule 7, if the execution of bond is not done by the IP owner, the customs should release the goods within 5 days, even though the IP is registered. What we discovered in our client case: no application is filed by the IP owner, no registration of IP, no execution of bond. But the customs authorities held the shipments for 4 long months, that too based on a patent which expired in 2022. How we responded? We built a response that hit every legal weak spot. We relied on the rule 4, 5 and 7 of IPR 2007 rules, and we also relied on 3 circulars issued by CBIC on this very aspect, like Circular 41 of 2007, 11 of 2011 and Circular 13 of 2012. We also relied on couple of judgments of Supreme Court and High Court, where it was categorically held that goods can't be detained just based on a complaint unless the IPR rules 2007 are followed. What was the result? From 4 months of deadlock, they got relief in 2.5 weeks. The client was surprised as they were expecting more time, as they got results faster than they ever imagined. So what are the key takeaways? A civil court order cannot give the customs the right to detain the goods unless the IP is registered and all the procedures prescribed under IPR 2007 rules are followed, and the customs has specifically banned the import of such goods. If these are not in place, you have every right to demand the release of the goods, and you know how to do it. If you find this video helpful, let me know in the comments about the topic which you want me to speak in my next video. See you in my next video.